The man I paid to protect me was the one robbing me blind. And the worst part? He did it while smiling at my face, calling me his most important client, and telling me I was too simple to understand what he was doing. He was right about one thing. I was too simple. Too simple to imagine that my own lawyer would sell me out for a bigger invoice. Let me take you back to the beginning. Not the dramatic part. The quiet, ordinary part. The part where everything still seemed fine. And the only thing wrong was a feeling. A small, cold feeling that sat in my chest like a stone I couldn't cough up. It was a Tuesday in late October. I remember because the light was already going at 4:30. That grey, flat kind of afternoon light that makes everything look used up. I was sitting in the waiting room of Hartman and Associates on the 3rd floor of a glass office building on the edge of the city. My left hand was resting on my knee. Not because I was relaxed, because my left hand doesn't grip the way it used to. The accident had seen to that. 18 months earlier, I had fallen from scaffolding on a construction site. 3 stories. I landed wrong. I broke my left wrist in 4 places, shattered 2 ribs, fractured my collarbone, and did enough damage to my shoulder that the surgeon told me I would never work at full capacity again. I was a tiler, had been, for 22 years. My hands were my livelihood. After the accident, my left hand was a reminder of what I had lost. The site owner's insurance company had accepted partial liability. There was a claim. There was a process. And there was my lawyer, Dr. Tobias Merck, a man in his mid-50s with silver hair, expensive cufflinks, and the kind of firm handshake that is designed to make you feel like you're in safe hands. I had found him through a referral from a friend. He had a good reputation. Personal injury, occupational accidents, insurance disputes. He knew this world. I didn't. That was the whole point. So I sat in his waiting room on that Tuesday afternoon, my damaged hand on my knee, and I waited. His assistant, a quiet woman named Frau Becker, offered me coffee. I took it. The cup was white with a small blue logo on the side. I held it with my right hand because my left couldn't grip it properly. That detail mattered later. Everything mattered later. Merck came out of his office and shook my hand. Firm grip, warm smile, direct eye contact. He was good at the performance. He ushered me in, closed the door, and sat down behind his desk. The desk was enormous, dark wood, almost black, covered in neat stacks of paper and 2 monitors. A small framed photo of a sailboat on the wall behind him. He told me the case was progressing. He told me the insurance company's legal team was difficult, that these things took time, that patience was a strategy in itself. He used the word strategy 3 times in 10 minutes. I counted. I asked him if there had been any offers, any settlement discussions. He leaned back in his chair, folded his hands, and gave me a patient smile. The smile you give a child who has asked a question that proves they don't understand the subject. "Not yet," he said. "Nothing worth bringing to you." I nodded. I drank my coffee. I went home. But something was wrong. I couldn't name it yet. It was just that stone in my chest. I want to explain something about who I was at that point in my life. I had spent 22 years working with my hands. I was not a man who read legal documents for fun. I was not a man who knew what procedural delay tactics meant or how billing hours worked in a personal injury case. I trusted professionals. I trusted the doctor who operated on my shoulder. I trusted the physiotherapist who told me which exercises to do. And I trusted my lawyer. Merck knew this. He had assessed me from the first meeting. I was a working-class man with a serious injury, a modest education, limited savings, and no experience with the legal system. I needed him more than he needed me. And he had built his entire approach to my case around that imbalance. The months passed. The case dragged. I received invoices, large ones. Merck billed by the hour, and the hours added up. I had taken out a legal expenses insurance policy years before, almost by accident, as part of a broader insurance package my broker had recommended. That policy covered my legal costs up to a certain ceiling. Merck knew the ceiling. He was billing toward it, slowly, methodically, like a man filling a bucket, one careful ladle at a time. I didn't understand this at the time. I understood it later. The thing that started to crack the surface was an email, a forwarded email. It came to me by mistake, or at least that is what I initially assumed. The insurance company's legal team had sent a communication to Merck's office, outlining a revised settlement position. Somewhere in the chain of correspondence, Frau Becker had forwarded the wrong attachment to me. She had meant to send me a procedural update. Instead, she sent me a thread of emails between Merck's office and the opposing counsel that went back 4 months. I read it 3 times. Then I read it again. The insurance company had made a formal settlement offer, a good one, significantly above what I had been told was on the table. The offer had been made in writing, with a deadline for response. The deadline had passed. Merck had never told me about it. I sat at my kitchen table with my laptop open and my coffee going cold, and I felt something shift inside me. Not rage. Not yet. Something quieter and colder than rage. The stone in my chest turned into something with edges. I did not call Merck. I did not forward the email back to Frau Becker or pretend I had never seen it. I saved it. I saved the entire thread. I printed it. I put the printed pages in a plastic folder, and I put the plastic folder in the drawer under my bed where I kept my important documents. Then I started paying attention. I want to be honest about something. Before the accident, I would not have described myself as a careful person. I was physical, practical, instinctive. I fixed things with my hands. I didn't document things. I didn't keep notes. But the accident had changed me in ways I was still discovering. I had spent months in recovery with too much time and too little to do. I had learned to be still. I had learned to wait. I had learned by necessity to observe. So I observed. I started keeping a notebook. I wrote down every phone call with Merck's office. Date, time, who I spoke to, what was said, what was promised. I wrote down every time I asked about the case and what answer I received. I wrote down every invoice, every amount, every line item. I cross-referenced the billing statements against the correspondence I had access to. I also started asking questions I had never asked before. Small, careful questions. Not accusatory, just curious. I asked Frau Becker casually whether there had been any recent communications from the opposing counsel. She said she would have to check. I asked Merck in our next meeting whether the other side had been in contact recently. He said nothing significant. I wrote that down. 6 weeks after I found the email, I received a second piece of evidence. A man named Peter Gruber called me. He was a former client of Merck's. We had met briefly at a community centre event 2 years earlier, just a passing conversation. He had heard through someone that I was in a legal dispute and that Merck was representing me. He asked if we could meet for coffee. We met at a bakery near the train station. He was a quiet man, a plumber in his early 60s. He had been injured at work 5 years ago. He had also hired Merck. He told me his story carefully, without drama, the way a man tells a story he has told before and has made peace with. Merck had done the same thing to him. Settlement offer withheld. Case extended. Billing maximized. Gruber had only found out afterward, when a colleague in a similar situation had compared notes and the pattern had become visible. By then it was too late for Gruber to do anything meaningful. The case had settled eventually for less than the original offer. Merck had collected his fees. Gruber had moved on. I asked Gruber if he still had any documentation. He did. Not much, but some. Enough. He gave me copies. I put them in the drawer under my bed with everything else. The third layer came from Merck himself. We had a meeting in January, about 14 months into the case. I'd been asking, repeatedly, about the timeline. When would this end? What were the realistic outcomes? What was the strategy? Merck leaned back in his chair behind that enormous dark desk, and he looked at me with a patient smile, and he said something I've never forgotten. Marcus says, Marcus, he said, because that is my name, Marcus Weil. I understand your frustration, but I need you to trust the process. These cases are complex. The strategy involves considerations that are frankly beyond the scope of what I can explain in a way that would be useful to you. I said, try me. He smiled again, differently this time, a small, condescending tightening at the corners of his mouth. With respect, he said, you're a craftsman, a good one, I'm sure. But the legal architecture of a personal injury dispute at this level involves procedural nuances that require years of specialized training to fully appreciate. You hired me precisely so that you don't have to understand it. That's what I'm here for. He said it kindly. That was the worst part. He said it the way you would say something kind, but what he meant was, you're too simple to understand this, and your simplicity is useful to me. I nodded. I said I appreciated his patience. I picked up my coat and my bag. I shook his hand. And then I went home and I wrote down every word he had said, as close to verbatim as I could manage, with the date and the time at the top of the page. I need to tell you about the CAMA, the Bar Association's mediation and disciplinary chamber. It is not a dramatic place. It meets in a municipal building with fluorescent lighting and chairs that have been uncomfortable since the 1980s. It handles complaints about lawyers, fee disputes, conduct issues, ethical violations. I had found out about it 3 months earlier from a legal aid advice centre I had visited on a Thursday afternoon without telling anyone, including Merck. A volunteer there, a retired judge named Frau Dr. Schreiber, had listened to my story for 40 minutes, asked very specific questions, and then told me quietly that what I was describing, if documented, constituted a serious breach of professional duty. Specifically, the withholding of a settlement offer from a client without disclosure was a disciplinary matter, not just a civil one. It could result in the revocation of a lawyer's license. She told me what I needed: documents, correspondence, evidence of the offer, and evidence that I had not been informed. A timeline, witnesses if possible. I had all of it. I filed a formal complaint with the Kammer in February. I did it myself, with Frau Dr. Schreiber's guidance, without hiring another lawyer. I did not tell Merck. I continued to attend our scheduled meetings. I continued to ask polite questions and receive evasive answers. I continued to write everything down. The Kammer scheduled a mediation hearing for the following April. Both parties would be present. Merck would receive formal notice 2 weeks before the date. I want to describe the morning of the hearing. I woke up at 5:30. It was still dark. I made coffee the same way I always do, in the small stovetop mocha pot my father left me. I sat at the kitchen table and I went through my folder one more time. Not because I needed to. I'd read everything so many times I could have recited it. I did it because the act of holding the documents was steadying. The paper was real. The dates were real. The words Merck had written in his emails to opposing counsel were real. The settlement offer he had buried was real. I put the folder in my bag. I put on my good jacket. I looked at my left hand for a moment, the way it sits slightly wrong now, the way the grip is never quite complete. Then I left the apartment. The mediation room was smaller than I expected. A long table, 6 chairs, a window with blinds half drawn against the morning light. The Kammer panel was 3 people: a chair, a senior lawyer appointed by the Bar Association, and an independent observer. Frau Dr. Schreiber was there as my supporting advisor, not as my legal representative, because I had specifically chosen to represent myself. Merck arrived 7 minutes late. He came in with the energy of a man who has been slightly inconvenienced by something he considers beneath him. He was dressed well. The silver hair was neat, the cufflinks were there. He had a junior colleague with him, a young man carrying a briefcase who looked like he had been told this would be a formality. Merck looked at me across the table and gave me the warm smile. The client smile, as if we were in his office and he was about to explain something patiently to me. "Marcus," he said, "I have to say I was surprised by this. I hope we can clear this up quickly." I said, "I hope so too." The chair of the panel opened the proceedings formally. She outlined the complaint that the respondent, Dr. Tobias Merck, had withheld a formal settlement offer from his client, Marcus Weil, without disclosure or written waiver, in apparent breach of professional duty under the relevant bar regulations. Merck's response was measured and confident. He acknowledged that a preliminary settlement communication had been received from opposing counsel, but characterized it as an informal exploratory contact, not a formal offer, and therefore not subject to mandatory disclosure. He said he had exercised professional judgment in not escalating a communication that did not meet the threshold of a serious proposal. He said he had acted entirely in his client's best interests. He said it well. He had clearly prepared. He was a lawyer, after all. The chair turned to me. I opened my folder. The first document I placed on the table was the email chain that Frau Becker had accidentally forwarded to me. I had brought 6 printed copies, 1 for each person at the table, including Merck and his colleague. I had highlighted the relevant sections in yellow. The settlement offer was formal, numbered, signed by the opposing counsel, and carried a response deadline. It was not exploratory. It was not preliminary. It was a written offer with a specific figure and specific terms. I watched Merck look at the document. I watched his expression change. Not dramatically, just slightly. A small tightening around the eyes. The warm smile did not come back. The second document was my telephone log. Every call to his office, every conversation, every question I had asked about whether offers had been received, and every answer I had been given. The log ran to 11 pages. The third set of documents was the billing records, cross-referenced against the timeline. The case had been billed at a rate that corresponded almost exactly to the pace required to exhaust my legal expenses insurance ceiling without triggering a review. I had prepared a simple table showing this. I was a tiler, not a statistician, but the pattern was not complicated. The fourth document was Peter Gruber's statement. He had agreed to provide a written account of his own experience with Merck. He had signed it. Frau Dr. Schreiber had witnessed it. The fifth and final document was a printout of my notes from the January meeting. The meeting where Merck had told me I was too simple to understand legal strategy. I had written it down within 30 minutes of leaving his office. The date, the time, the words, as close to exact as I could make them. I did not make a speech. I did not accuse him of anything beyond what the documents showed. I placed each document on the table and I described briefly and factually what it was and why it was relevant. The room was quiet. Merck's junior colleague was leaning over, whispering. Merck was very still. The chair of the panel asked Merck if he wished to respond to the specific documentation. What followed was not a dramatic collapse. It was more like watching something lose structural integrity slowly. He began with denial. The email had been mischaracterized. The offer had been genuinely insufficient. He had used professional judgment. Then he shifted to technical arguments about the definition of a formal offer under bar regulations. The chair interrupted him twice to ask specific questions he could not answer cleanly. His junior colleague stopped whispering and started taking notes very quickly. Then Merck tried something I had not expected. He turned to me and he said, in a voice that had lost its warmth entirely, that I had clearly been coached, that I had clearly had outside legal assistance in preparing this complaint, and that the documentation I had presented was suspiciously comprehensive for a layperson. I said that I had kept notes because I had learned after 22 years of working with my hands that the details of a job matter, that you measure twice, that you write things down, that you don't rely on memory when precision is required. I said it calmly, because I was calm. The chair adjourned the session to allow the panel to review the documentation. The formal outcome came 6 weeks later. The panel found that Merck had withheld a material settlement offer without proper disclosure, in breach of professional duty. The finding was referred to the full disciplinary committee of the Bar Association. I want to tell you what happened after that, because this is where the consequences become real, and the story stops being just mine. The disciplinary committee reviewed the case over 3 months. They had the panel's findings, my documentation, Gruber's statement, and the results of a broader review they had initiated into Merck's billing practices across multiple cases. I was not the only one. There were 4 other former clients with similar patterns. I had not known this when I filed my complaint. The committee had found it. Merck's practicing certificate was suspended pending the full investigation. His application for renewal of his specialist accreditation in personal injury law, which had been under review, was withdrawn by the accreditation body. The insurance company in my original case, informed of the disciplinary findings, agreed to reopen settlement discussions. Without Merck, without the billing game, without the procedural delay tactics, the negotiation took 11 days. 11 days. I received a settlement that was significantly above what I had been told was realistic and substantially close to the original offer that had been buried. It did not make me whole. Nothing was going to make me whole. My hand was still damaged. I was still not going to tile at full capacity again. But it was fair. It was what I was owed. The legal expenses insurer, informed of the billing irregularities, initiated their own recovery proceedings against Merck for fees paid under the policy that were later deemed to have been generated through artificial case extension. I was not directly involved in that, but I was told about it. Merck's firm did not survive the year. The suspension, the publicity, the loss of clients, the recovery proceedings. The building on the edge of the city with the glass front and the 3rd-floor office and the enormous dark desk. I drove past it once, about 8 months later. The sign was gone from the front. The windows were dark. Frau Becker, I heard later, had found a position with another firm. I hope she is well. She made a mistake with that forwarded email, and that mistake changed everything. I have never been angry at her for it. Let me tell you about the white coffee cup, the one with the small blue logo, the one from Merck's waiting room, the one I had held in my right hand because my left couldn't grip it properly. I thought about that cup a lot during the months of building my case. It was a small thing, a detail, but it kept coming back to me as a symbol of something I couldn't quite name. I think what it represented was the moment before I knew. The moment when I was still a client, still trusting, still holding a cup of coffee in the wrong hand, and not yet understanding why any of it mattered. After the settlement came through, I went to a ceramics market in the city. I bought myself a coffee cup, a good one, handmade, thick-walled, with a proper wide handle. I can grip it with my left hand. Not perfectly, but enough. I drink my coffee from it every morning. I want to say something about authority because this story is partly about that. I grew up in a world where certain people knew things you didn't. Doctors, lawyers, engineers. You went to them because they had knowledge you lacked, and you trusted them because the alternative was to try to acquire that knowledge yourself, which took years and cost money and was simply not practical for most people living ordinary lives. That trust is not stupid. It is rational. It is how society functions. But trust without verification is not trust. It is surrender. Merck had counted on my surrender. He had looked at me across his enormous desk and assessed me as someone who would not check, would not document, would not ask the right questions at the right time. He was right about the man I'd been before the accident. He was wrong about the man I had become during the recovery. The accident had taken things from me. My full grip, my capacity for certain kinds of work, a version of my future I had assumed was fixed. But it had also given me something. Time. Stillness. The habit of paying attention to small things, because small things were all I had for months. Merck called that simplicity. I call it precision. There is one more thing I want to tell you. About 3 months after the settlement, I received a letter. It was from Merck. Not through lawyers, not formal, just a letter in an envelope with his personal return address, not the firm's. It was 2 paragraphs. In the first paragraph, he said that he regretted how things had unfolded and that he had not intended to cause harm. In the second paragraph, he said he hoped I understood that the pressures of running a practice were significant and that he had made decisions he now recognized as errors. He did not apologize. Not directly. Not for the specific thing he had done. He apologized for how things had unfolded, which is not the same thing at all. I read the letter twice. Then I put it in the drawer under my bed with all the other documents. I did not reply. Not because I was still angry. I was not, particularly. But because there was nothing to say that the documents had not already said more clearly than I could. I want to end with something honest. The settlement money did not fix my hand. It covered the medical costs I had already paid and the income I had lost, and some portion of the future income I would lose. It gave me a financial foundation I had not had since the accident. I used part of it to retrain. I'm now working in a supervisory capacity on construction sites. I assess. I plan. I manage. I use my experience and my eye and my knowledge. I use a clipboard more than a trowel. I am not the same man I was on the scaffolding 18 months before the accident. I am not even the man I was in the waiting room with the white coffee cup. I am something else. Something that was made partly by falling and partly by what I found in my drawer when I started looking. Merck told me I was too simple to understand legal strategy. He was the one who didn't understand the strategy. The strategy was patience, documentation, the willingness to let a man believe he was winning, right up until the moment you place 6 copies of his own emails on a table in front of a disciplinary panel. I learned something I should have known earlier. The person sitting across the desk from you is not automatically on your side. Not the doctor, not the contractor, not the financial advisor, and not the lawyer. They may be. Many of them are. But maybe is not the same as is. And the difference between those 2 words is a notebook and a plastic folder and the habit of writing down the date. I drink my coffee every morning from the cup with the wide handle. My left hand grips it. Not perfectly, but enough. That is sufficient. That has always been sufficient.